Welcome to another episode of Plaintiff Prep. In this season, we're talking all about mediations, and today we're going to be talking about the factors to consider before attempting mediation. So, let's get right into it.
The first factor is ripeness. One of the questions we might want to ask before attempting mediation is this: are you finished getting medical treatment? Typically, a settlement is accompanied by what's known as a release of claims. In other words, the defense cuts you a check, and in return, you sign a release which basically says that you will never again sue that defendant for the same incident. Once you release the defendant, you cannot come back later and get more money for that incident or more money for the injuries caused as a result of that incident. Therefore, it's critical that you and your attorney know the full extent of your injuries prior to settling the case. That way, you won't settle for an unreasonably low amount of money. Put another way, you don't want to settle too soon and release the defendant only to find out months down the road that you're going to need an additional major surgery that costs thousands of dollars.
The second factor is the party's willingness to compromise. Perhaps the most important factor to consider when you're determining whether or not to attempt mediation is the party's willingness to compromise. Mediation is expensive and time-consuming. Therefore, if neither of the parties are willing to settle the case, and if there's no way they can compromise, mediation could be a total waste of time and money. Now, in some cases, and in some states, mediation is required. For example, there's a mandatory mediation requirement for medical malpractice cases in South Carolina and Florida. In those situations where the law requires mediation, it doesn't really matter how willing the parties are to compromise. They have to give it a try, regardless of how stubborn and recalcitrant the parties are. However, in those situations where mediation is optional, the party's willingness to compromise could be the deciding factor as to whether the parties should attempt mediation.
The third factor is cost. In some cases, the court might provide a mediator for free. In other situations, the parties have to pay for mediation. Usually, mediations are not cheap, and it's not uncommon for mediation to cost hundreds or even thousands of dollars, depending on the specific case and how long the mediation lasts. Therefore, as we alluded to a minute ago, if neither party is likely to compromise, it probably won't make sense to take on the cost of mediation.
The fourth factor is the defendant's liability. If the defendant is clearly liable, the defendant will be much more likely to settle the case for a reasonable amount of money. In those circumstances, mediation could be a fantastic option for both parties. When we're talking about whether the defendant is liable, we're essentially asking this question: what are the chances the jury will find the defendant to be at fault? The answer to this question depends on several factors. First, we look at the evidence we have, and what our investigation shows is the actual cause of the accident. Then we look at the defendant's defenses or excuses and whether the defendant will likely be able to prove those defenses. We look at the law regarding the defendant's fault under the circumstances, and we look at whether the plaintiff would share some of that fault. These factors combined help us to gain an overall understanding of the defendant's liability.
The fifth factor is the nature and extent of your damages. The nature and extent of your damages will largely determine the amount of money you're willing to settle for. More damages warrant a higher settlement amount, and a stubborn defendant may not want to pay up. In these situations where the damages justify a settlement amount far above what the defendant is willing to pay, mediation may not make sense. The extent of damages in a personal injury lawsuit will depend on many factors. Some of those factors include whether your injuries are permanent, whether your injuries are disfiguring, whether your injuries are disabling, whether your injuries have been confirmed by a doctor or an expert, whether you will require medical treatment in the future, whether you have missed out on income in the past and whether you will miss out on income in the future. And finally, whether you have a reduced earning capacity as a result of your injuries.
In summary, mediation is a fantastic tool in a lawyer's toolbox. When it works great, and the parties get to move on with their lives and avoid further litigation. Each of the 5 factors we discussed today can help you and your attorney determine whether or not to attempt mediation. For the sake of repetition, those 5 factors are as follows. 1, ripeness. In other words, are we aware of all of your damages, and are we ready to settle the case? 2, willingness to compromise. Are the parties willing and ready to settle the case, or are they still very stubborn? 3, cost. Is it worth it to spend the money on mediation, or are we just wasting everyone's time and money? Or does the law require us to attempt mediation? 4, defendant's liability. Is the defendant clearly and obviously liable such that the defendant is going to get smacked by the jury? 5, nature and extent of your damages. How bad are your injuries? And what kind of check is the defendant going to have to write in order to get you to settle the case?